Welcome. We've got the usual high-quality, entertaining program for you this morning. CBD points and food. You can't beat it. A little bit about Georgina. Green have included in your welcome pack all the usual. Georgina is a practitioner who is specialising in commercial and administrative law broadly, and she comes out of a very good background. It's a bit like a stud situation, the property law department at Mallisons. So without further ado, Georgina.
Well, thank you all for coming so early. It's school holidays, so if any of you had those logistics, I'm extra grateful to you. I really enjoyed being a property solicitor, and I think some of you probably still are property solicitors. The good thing about being a property solicitor is that you actually get to do some case law. You have to look up some cases at times, whereas sometimes in the M&A area, it's not so much about the black letter law. But as barristers, we get the brief and we get the benefit of hindsight. And you sit there in your chambers looking at the documents and thinking, if only they drafted the contract with this particular default clause, or if only in the rescission notice they'd said this. And it's a luxurious position, hindsight. We're not there with you at the moment that you're under pressure to do something fast and you've got to juggle all your other matters. But hopefully what you'll take away from today is that next time you sit down to draft a rescission notice, or you sit down to resist the effectiveness of a rescission notice, you'll just be aware of some of the main pitfalls that seem to arise in cases I've looked at and rescission notices I've seen. I was thinking about the context that these rescission notices would arise for you in advising in relation to contracts of sale of land, and it seemed that there are two main times they arise. One is where you're acting for a purchaser and the purchaser would like to get out of buying the property. And on the other hand, you might be acting for the vendor and the purchaser is not paying and the vendor would like to end the contract and sell the land to someone else. These would probably arise in the following typical scenarios. One is where there's been a failure to pay some or all of the purchase price. Another is where a purchaser may rescind an off-the-plan contract of sale, for example, where the plan of subdivision is not registered within 18 months of the date of the contract. And there have been a couple of cases where purchasers have successfully rescinded contracts on that basis. You may be familiar with the cases of Allen and Harafam, which is a case from this year, where the Chief Justice of the Supreme Court followed favourably a previous decision of Justice Bongiorno, and in both those cases purchasers were allowed out of the contract under Section 9E of the Sale of Land Act, and they would have rescinded the contracts. It also might arise, a rescission scenario might arise where there's been a material amendment to the plan of subdivision and Section 9AC2 of the Sale of Land Act applies, or the purchaser is unable to obtain finance and rescinds under the subject to finance clause. A purchaser may rescind where the vendor hasn't complied with the vendor statement requirements under Section 32. So those are some of the areas where this may come up for you. Now, behind me, I've written a poor rescission notice. Now, there's something called fundamental attribution error, which I heard about. Psychologists talk about if you say something about someone else that's a criticism, people tend to remember that about you. So I'd just like you all to know that this is a bad rescission notice. This is not a precedent for you to use, and I tried to make it bad on purpose. So I'd like to tell you what the case law is on problems with rescission notices, when they're fatal, when they're not, and then after I've done that, I'd like to invite you to help describe the faults with this one. So in summary, notices must be clear and unambiguous. the person who receives the notice must be able to know what you mean by it. What this means is that you need to be careful in drafting a rescission notice about the following things. Who is the notice to? Is it to the purchaser? Is there a nominee in the fact scenario? Is it addressed to the right person? How is it to be served or provided under the contract? Is it to be provided by fax, by email, to the solicitor, to the party? If it's a company, is it to be provided to their registered office? Is there an address for service? What is the default that you seek to rescind under? And this means you really need to carefully look at the contract and you need to say what clause has been breached. What is required to remedy the default? Rescission notices usually say remedy the following default within 14 days or we end the contract. So what is the default? What have they done wrong? And what is the consequence if the default's not remedied? If it's not remedied, is the contract brought to an end? If that's the case, that needs to be said clearly. One of the main cases in this area, and in any submissions done to a court on the rescission notice, I think you'd see this one cited, is the case of Catley and Watson, which is a 1981 case in the Supreme Court. It's a decision of Justice Brooking. And in that case, Justice Brooking held that the rescission notice was not effective to rescind the contract because the notice failed to use words that clearly indicated that unless the default was remedied, the contract would be rescinded. His Honour held that a reasonable person, having regard to the terms of the contract and looking at the rescission notice and giving it fair and proper consideration, would have doubt as to its meaning. Now, this case was recently cited in the decision of Justice Hargraves in U108 Pty Ltd and Singh Fan. It's 2010 VSC 12. Now, I'll just pause there to mention that in many of the cases that I looked at in preparing today, I saw my esteemed colleagues were barristers in those cases, Mr Little and Mr McKenzie, and also Mr Rimmer, who's also on my list. And something about the culture of the bar is when we get a curly question, we ring each other and ask. So it's nothing but a brazen plug for the bar to say this, but if you are sitting in your office and confused about a rescission notice, you could do what we do when we think it's a difficult call and ring and ask one of us, someone on Green's list, for help in working that out. So the cases that I'll talk about often involve my learned friends and others. So in the decision of U108, Justice Hargraves heard the matter in the practice court, and in this case, the vendors had tried twice to get the rescission notice right. There were 2 rescission notices, but neither of them did the trick. At paragraph 43, Justice Hargraves cited Catley and Watson, the decision of Justice Brooking, and he cited the following passage. A notice is not unequivocal in the sense in which such notices are required to be unequivocal in relation to their essential contents if a reasonable person, having considered the notice as a whole, fairly and properly, might entertain a doubt as to its meaning in relation to some essential matters, even though he would form in his mind a preference for one view rather than the other of what the notice was intended to convey. It must be possible to say that after the appropriate consideration, any doubts that may have arisen would be quieted and the purchaser would not be left in any uncertainty as to the meaning of the notice. Justice Hargrave cited some further cases and summarised the authorities as saying, a reasonable reader in the position of the purchaser must be taken as one who knows the terms of the contract of sale and who is aware of the surrounding circumstances relating to the default. So if looking at the rescission notice, knowing what the contract says and knowing the surrounding circumstances, it's really clear what has been done wrong and what has to be done to rectify the default, then even a sloppy rescission notice might be all right and it might be upheld. But don't take that risk, because if there's ambiguity and it's taken to not be clear what the rescission notice says, then the rescission notice will be invalid. So in this case, there were 2 rescission notices, and the second rescission notice did not make any reference to the first rescission notice. And this meant that it wasn't clear whether the date by which the default needed to be remedied in the first notice was the applicable date, or the date by which the default needed to be remedied in the second notice was the applicable date. And His Honour said at paragraph 45, they might entertain a doubt as to whether the interest they were required to pay by the notice in order to avoid rescission should be calculated from 4 November 2009, the date in the first rescission notice, or 5 November 2009, the date in the second notice. In these circumstances, His Honour found the rescission notices invalid. He noted that the rescission notices were replete with typographical errors, cross-referencing anomalies, and that even though he'd already said it was invalid for the reasons I've explained, he also found that it was unsatisfactory that the rescission notice said that the contract of sale will be rescinded pursuant to General Condition 28 of the contract of sale when there was no such condition in the contract. The rescission notices specified the wrong balance of the purchase price that was due, and His Honour described the rescission notices as reflecting extremely sloppy conveyancing practice. So don't get into that sort of situation. By contrast, a more recent decision in the Associate Judge's Court, Associate Justice Mukhtar made this decision, went the other way and found that although the rescission notice in that case had a few problems, none of them were fatal. The purchaser could see what the vendor meant. And that decision is the case of Damco Nominees, Pty Ltd, and Moxham. It's 2012 VSC 79. Associate Justice Mukhtar is a very pleasant judge to appear before. He's very thorough, and as usual, he's written a very thorough judgment that contains quite helpful references to authorities and a detailed explanation of the facts. In that case, the faults with the rescission notice were that there was incorrect addition of default interest and legal fees. It used the term proper legal costs instead of reasonable legal costs. It had an incorrect method of calculating interest, and it contained a typo, buyer's costs instead of seller's costs. You can glean that those errors do seem to be less problematic than the errors in the case of U108. They are more technical ones that you can see. You could imagine that you could see through the problems with it and understand what the vendor meant. But even though the vendor in that case was able to rely on the rescission notice, the sloppiness in the way that the rescission notice had been drafted meant that a case had to happen in the practice court to determine whether the rescission notice was valid or not. So that is unfortunate for a vendor when, by drafting the rescission notice properly, the parties may have had a clear legal position and been able to get on with it. Instead, it's just good work for barristers. In another case from 1991, a decision of Justice Nathan in Lintle Pines Pty Ltd and Nixon, reported in Volume 1 of the Victorian Reports at page 287, Justice Nathan held that the rescission notice was not effective because it failed to state that the rescission was pursuant to Clause 16 of the contract. Clause 16 of the contract said that time shall be of the essence and no party shall be entitled to enforce its rights unless and until written notice has been given specifying the default and stating the intention to enforce such a right. Justice Nathan held that a rescission notice must strictly comply and absolutely comply with the contractual requirements, and it was a requirement of the contract that the notice rescission refer to clause 16. So the problem with that rescission notice was a failure to refer to the default clause. And I'll just take you to one more case, the case of Kuzmanovic and Eliminit, Pty Ltd, a 2002 Supreme Court case, VSC 363, a decision of Justice Harper. In that case, the rescission notice was held to be ineffective. The purchasers had failed to settle on the settlement date. The notice said, unless the default's remedied within the remedy time, the contract shall be rescinded pursuant to Condition 2 of Table A. The relevant condition was Condition 6, not Condition 2. The amount which the notice said was in default was incorrect. His Honour Justice Harper said, the notice of rescission is ineffective. While the reference to the incorrect condition may not of itself be fatal, the insertion of the incorrect amount, payment of which will remedy the default, does, it seems to me, destroy the document's validity. A defaulting purchaser is entitled to be informed accurately and in writing of exactly how much must be paid if the default is to be remedied. If a rescission notice is defective and invalid, it's not the end of the story, because the case law tells us that even if a rescission notice gets some fundamental things wrong and can't be relied on to rescind the contract, it can be effective to make time of the essence. It can be effective to send a message to the other side that they need to remedy the default or they will be repudiating the contract. So in the case of Aussie Invest Corp Pty Ltd and Pulchesa Pty Ltd, 2005 VSC 362, Her Honour Justice Dodd-Streeton, Justice of Appeal Dodd-Streeton, heard an argument that a rescission notice had not been served in accordance with the notice requirements in the contract, and in the end decided that looking at the contractual provisions read together with Table A of the 7th Schedule of the Transfer of Land Act that applied in that case, they could get away with the notice in the form that they had done it. But in Obiter, she said, even if the rescission notice was invalid, it made time of the essence, and the purchaser's failure to pay the money due in 14 days constituted repudiation of the contract, which entitled the vendor to rescind. This was also the approach taken in a case from 2000 in the Court of Appeal, a bench of Justices of Appeal Ormiston, Charles and Callaway, in the decision of McRae and Bellaro Pty Ltd, 2000 VSCA 72. In that case, the trial judge had found that the rescission notice was defective because it allowed 14 days rather than 18 days to remedy the default, whereas the contract required 14 days' notice. But the trial judge, in a decision upheld by the Court of Appeal, found for the vendor, because even though the notice was ineffective, the purchasers had repudiated the contract by failing to pay the money, and thus were liable in damages for what was in effect a shortfall in resale of the land. So I think I've told you enough to make it easy, I hope, for you to pick the eyes out of this default notice. And if it's too early to participate, well, I'll throw the questions to my learned panel. But does anyone want to suggest anything that could be better about this default notice or this rescission notice? Now, apparently I've got a pointy thing. Where's that gone? Where's my trusty laser? Now, I'll just give you a moment of light relief to tell you something about a laser. When I was growing up, my brother was a bit of a tearaway, and with a great sense of humour. And my dad was going to do a lecture, and he had this laser pointer. So my brother sat up high where there was this window looking over to the neighbour's house, and he used this very powerful laser pointer while they were watching TV, and he'd watch the neighbours going like this and seeing this red thing on the TV, which would have been hilarious, except that the neighbour was a solicitor and he was involved in a case where there'd been threats against him and his family by the client on the other side. And every time I run into that solicitor, I just think, oh, because it was just this traumatic sort of event. It was very embarrassing. Anyway, so I'll just aim this at the correct place. And anyone? Yep.
Even though this is headed notice of termination, I would interpret this to be more of notice of time of the essence, which has become in vogue because of recent decisions in the last few years. So, especially the last part where it says your client may be in default. So really this is freshening up time of the essence, I would have thought. I would have thought that this vendor has a chance to issue a rescission notice after the 14th.
Yeah, absolutely. That's a great point. And the thing is that I've seen one like this where the solicitors thought they were doing a rescission notice, but they didn't call it a rescission notice, and it didn't really look like a rescission notice, and they needed to do another one, down the track. So it's a good idea. If you want to do a rescission notice, make it a rescission notice rather than something like this or something that's a notice to complete, which would really, as you say, just make time of the essence. It shouldn't be in a letter form either. It should be a notice of rescission if that's what you're trying to do. Anyone else got a suggestion? Yep.
Should be addressed to the purchaser, not the solicitor.
Yeah, that's right. Should be addressed to the purchaser, not the solicitor, and also checking exactly who at the purchaser and what address. And when in doubt, send it 3 different ways to 3 different recipients, but don't get that wrong. Anyone else? Yeah, doesn't refer to which clause of the contract they've breached. It just says failed to complete settlement. Anyone else?
I'll jump in. The other obvious one, which I remember well from Danco and Moxham, which is the contract requires that you say together with the proper legal costs. It says listing, interest, costs. And Nathan Cooper-Hulse and I had a big discussion about the proper costs of a notice. He said he had to reread his whole personalised contract from start to finish, and the costers got into it. We had one, they had one. They both agreed about $1,000 to reread your contract when you give a notice. I said there's 3 clauses you need to look at, that's all, 350 max, but those days are gone. The 2 cost consultants got in and they both agreed that $1,000 or more. And when you look at the term of the contract, you'll find a figure that says this, and proper costs. Nathan has said proper costs of the purchaser, but as has been said, that wasn't regarded as a significant difference. It was the cost of the vendor, and we should have known that.
Another one is that it says here, your client shall complete settlement by 14 October or your client may be in default. That's terrible language. It's got to be unequivocal. It's like when you really are mad with your kids and you give them the 1, 2, 3. Like, if you don't get in the bath yourself in 3, I will put you in the bath in your clothes. And they know exactly what they have to do in 3, okay? No, none of this, come on, darling, hop in the bath. Another problem with that one was that it doesn't, so it doesn't say what term is breached or which terms of the contract are relevant in terms of default. It doesn't rely upon the default clause. I'd also remind you to get the description of land right. Look at what it says in the contract. Is it a street address? Is it a volume folio? Just make sure you get that right.
Can I ask Georgina a question without notice? bearing in mind what Hargrave said about the 2 notices in the U108 case, it's not unusual. You look at a default notice and you go, oh, that's got some problems. And then you've got the decision. Do you fly with the one you've got that you think's a bit suspect, or do you issue another one? Particularly when Hargrave said there were 2 out there and the combination is even more confusing. You might have dealt with that, but it's...
Well, it is something I have dealt with when I've looked at a brief with a not very good notice in it. And I think Hargraves leaves one area open. He says part of the problem is that the second notice didn't refer to the first notice. So if you are going to send a second notice, make sure that it cancels the first notice and makes it clear that to remedy the breach, you have to comply with this notice by this date by doing this. On the other hand, you can get in trouble with varying the contractual terms through conduct between the parties. So often, I'm sure in your experience, vendors have been willing to allow purchasers a bit more time. And so the original settlement date in the contract isn't really the date anymore. So you can be in a situation where you may, in your rescission notice, have to set out some detail about why that date that you now say is the date by which they have to pay is the date. You might say the settlement date in the contract was the 1st of June. It was varied and agreed by the parties that it would be the 15th of June. You still didn't settle on that date. We sent you a notice to complete to do it by the 30th of June. You didn't do it by that date. We're now giving you a rescission notice. Pay the money by the 14th of August. If not, we will rescind. I think if you did a rescission notice like that, it could be all right. But on the other hand, you might choose to just go with the rescission notice you've got and rely on the lack of compliance with the contract and treat that as a repudiation of the contract, entitling your client to rescind, and therefore you don't have to worry about the rescission notice. When it gets to the point of doing the pleading and working out, so you've got a rescission notice there, it's a while back, they still haven't paid the money, do you do a new rescission notice now or do you just issue? You might choose to just issue, relying on not knowing whether in their defence they'll attack the rescission notice or not. They may not. So if they don't attack the rescission notice, you could rely on it. If they do attack the rescission notice, then you can argue that even though the rescission notice was defective, it made time of the essence, they still didn't perform, therefore it constituted repudiation, the contract's at an end. So there are difficult decisions to make, and if you have drafted a contract with clear clauses and you've drafted a rescission notice that gets it right, these decisions will be much easier. And what will then happen is your client will be in a position, if it has to issue proceedings, to get summary judgment against the other side. So there's a very recent case there's a recent case of Justice LaCava in the County Court in Singleton and Marina Apartments. It was a case, the judgment delivered on 5th of September 2012. It's 2012 VCC 1341. It doesn't cite much authority. It's not so much a case you'd cite, but I thought it was an interesting example of where the solicitors did a good job for the purchaser, because they'd done a good rescission notice that summarised succinctly and accurately a complicated breach in terms of a material difference in the property as built compared with the architectural plans. They'd served it properly and they relied on the rescission notice to rescind the contract, and they got summary dismissal or summary judgment at court. So by doing these things, you set your client up for a quick victory, which would keep them happy. Now, I just end now, but finally I will say that I'm grateful to Mitch for pointing out to me a useful precedent rescission notice that's contained in Appendix 3 of a booklet from the Legal Practitioners Liability Committee. That's a pretty good source, because you can't be sued for relying on that one. And it sets out an example rescission notice, which is a good place to start. Thanks.